now we're at the closing. Before we go there, Chapter 21 is going to be closing the real estate transaction. But when we get to the closing, we have to do a few things. We have to, we made promises. I promised to bring the money. You promised to bring the title, a clear title, general warranty deed. All right. We have to make sure that those things happen. Okay. We have to make sure that the mortgage funds are distributed. Okay. Buyer's got to get money so that he can pay the seller or she can pay the seller. We have to make sure we have clean title. Am I passing good title if I'm the seller? Do I have the ability to sell this property? Right? Am I going to get enough money so I can pay off the liens that are on this property? Those things have to be checked before that. And any other settlement costs or funds are dispersed. Now, here we're also in the closing in North Carolina. We have to record the deed. Well, before we disperse any kind of funds to the brokers, to the seller, to anybody, that deed has to be recorded. That's when it's considered closed. Okay? That's when it's considered closed. Not until the title search is complete and the deed has been recorded. That's when everybody gets paid. All right. Ultimately, they're going to check in on the title search once last time, and they're going to record the deed. And then once that happens, they'll have the right to disperse the funds. Otherwise not. One of the things about when we get close to closing, right away, the seller wants to cancel the insurance. Well, you got to make sure that the seller keeps the insurance through closing. Because what happens if we get a delay? What happens if we come to closing table and something's missing and we got to postpone it for 3 or 4 days? Does the seller really want that house sitting without insurance for 3 or 4 days? I don't think so, right? So tell them that cancel it after the closing. Make sure the house closes, then cancel it. Same thing with the buyer. Make sure the buyer's insurance is for the day of closing and onward. It's fine to have it for 3 or 4 days with 2 insurances. Nobody's going to die. If the house burns down and no insurance, though, that's going to be a nightmare. All right. So it's extremely important for the buyer and the seller to have appropriate insurance coverage in situations where the closing is delayed, when the buyer will occupy the property before the closing, and when the seller will occupy the property after closing. That happens sometimes. I would strongly suggest that you try to avoid that like the plague, the buyer moving in early or the selling staying later. The seller would be responsible still. The problem is that what happens if now we have the closing and the seller hasn't moved out yet? Technically, it's the buyer's house. What if the seller has an accident, sets the place on fire? Whose fault is that? That's why it's not a good idea. All right. Now, I'm not a lawyer and I'm not a judge, but I don't want to be that person, that intermediary. That's why it's not a good idea to do those things. On the settlement day, buyer moves in, seller moves out. That's the best of all worlds, right? Anything else is a problem or a potential problem. Not a big advocate of that, even though I moved in early, so I can't be too big of an advocate against it, but I wasn't going anywhere. Plus, my house was empty, so that's okay. All right. Now, when we got into contract, when we were the buyer, we got into this contract. We gave due diligence money. Remember that back in when we were talking about contracts, chapter 10, right? So in that due diligence period, we have to get a few things settled. We have to make sure we can get our loan. We have to get our investigation done, our home inspections during that period. We have to make sure we have insurance on the property. Can we get insurance on the property? Are we in a flood zone? Any of those things. Appraisals, surveys. Do we have the proper septic system? If we're city water and city sewer, this isn't a problem. If it's on-site septic, do we have enough septic to handle our water issues? We have to find that out. Go to the Board of Health, find out. If we're going to get repairs or improvements, are we going to negotiate it? We're going to try to get some money for them. We're going to try to get them fixed. We have to do that all inside the time frame of this due diligence process. We can't do it afterwards. During that process, we have the right to terminate it. For any reason or no reason at all, we can terminate. All right? And then we have physical inspection, anything we need to do during the period. Now remember that when we're doing due diligence and we give you a date and a time, 5 p.m. on this date. You can't do as the buyer anything else after 5 p.m. That's it. You bought it, right? And you could lose your earnest money if you walked away. But if you walked away during that due diligence period, you're going to lose your due diligence money, obviously. However, you're going to be able to keep your earnest money. So if we say 5 p.m. on February 1, it's a hard date, not 5/10. Some of the things that we should be checking as buyers. Do they have tenants? How long is that lease going to run? Is the lease over? I can't just buy the house and throw the tenants out. I have to abide by the lease, right? I'm buying the lease, so if there are tenants in there. Do we have any easements on that property? Any encroachments on the property? Are there, do we have building permits on any recent construction? What about mechanics liens? Have they been paid? Do we violate any of the zoning or restrictive covenants when we did anything? Has there been anything in there? I got to check that, right? And we talked about the on-site septic system, if it's appropriate, and other lead-based paint inspections, if they want to do radon, asbestos, mold, well water. We have to do those all within the due diligence period, okay? All within the due diligence period. Now, the buyer has the right to terminate during that due diligence period for any reason or no reason at all right? 5 p.m. on the date stated in the due diligence procedure, all right, for any reason or no reason. But 5 p.m. is a hard date, okay? And this is a unilateral contract. Some other things that are going to happen while we're doing this, all right, we're going to get the title examination by the attorney. So he's going to be checking to make sure we have clear title. He's going to be checking the chain of title, the abstracts, making sure that there's no objections to it. All right. If there are some title defects, he's going to have to clear them. He's going to have to do some quick claim deeds or have some have a suit to quiet title. In that particular case, he may have to call people to court, get those things settled. Happens once in a while. Right. They're going to have to get the loan closing package by the lender with the money in it. They're going to have to do that. If the brokerage is holding earnest money, they have to send it to the attorney's office so that they can close. However, they are not allowed to send that money to the attorney's office prior to 10 days before the closing. So one of the things that's happening now is they're just letting the attorneys handle it from day one. Just give it to the attorney's escrow account. But if we take it and we put it in our escrow account, we're not allowed to transfer it to the attorney prior to 10 days before closing. We can't just take it and then ship it to the attorney for them to hold it. That's not the case, right? 10 days prior to settlement. All right, brokers working with seller and the buyer. Perform advanced review of the settlement statement if available. All right, this is important for you. This is important for you. A review of the final settlement statement is mandatory. You have to check if you're the buyer's agent, you got to check the buyer's side of that. If you're the seller's agent, you got to check the seller's side of that. You got to make sure it's accurate to the best of your ability. Okay. And yes, there might be some numbers you won't know, but you can make the phone calls, right? Ask, question it. All right. At that point, we're going to have to notify the buyer about how much of guaranteed funds they're going to need to close, how much they're going to wire. Make sure that we follow our wiring rules, right? Be very, very careful about where they're going to wire. Have them get some voice contact about where they're where to get their wire to, right? Make sure that they understand. Don't make any mistakes there. That's a lot of money that'll disappear. And then the settlement agent or the attorney arranges for title insurance. That's part of the title search. Now, the settlement date and the closing date are different. There are two different things. The settlement date is when we get all this stuff together, we start signing documents. We get everything together, we sign the documents, we move on. The closing is, we spoke about this at the beginning, the closing is when the deed's recorded and the final title search is checked. Then we can distribute the funds, but not until then. And that is after the settlement. We settle first, then we go to closing. Could be the same day, depending on how fast they can get that done. Could be the day after, depends. All right, depends on the timing of everything. Now, let me just say this, and it's not in any slide. Try not to close on a Friday. try to keep your closings in the middle of the week, because North Carolina is no different than any other southern state down here. At 1 o'clock on a Friday afternoon, a lot of these businesses close, right? I mean, you know who they are, especially in summertime. Summertime, you get these long weekends. Well, let's say there's a little delay in the closing on Friday, and maybe the documents aren't there and they don't get there till 2 o'clock in the afternoon. And we can't close on a Friday. Or if we can settle on a Friday, we can't close. Do you want your buyer to be living in their rental truck for the weekend till they can close on Monday? Not a good idea. So make sure that try to schedule it in the middle of the week. Give yourself a little playtime, a little time to, if something goes wrong. Wednesday's a good day, right? Maybe Thursday if you got to go to Friday, but don't schedule them for Fridays, because you'll end up putting up your clients in a hotel. That won't be fun. All right, so we're going to do all of this, right? Location, we're going to be at the location where the meeting's conducted. Parties are going to attend the settlement meeting. We're going to review the final statement, and then we're going to collect the funds due from the buyer. And we talked about this difference between a settlement meeting and then a settlement agent. That this is going to be an attorney. Settlement agent is usually the buyer's attorney, and it has to be done by an attorney because it is practice of law. Right? It is a practice of law. The settlement attorney is going to take the seller's social security number, the sale, and everything else, and report it directly to the IRS. Now, in some cases, you won't. We haven't talked about capital gains yet. We'll talk about that next week. But if you don't have any taxes due, that's fine. But if you do have taxes due, the IRS knows already. At the closing, the attorney is required to send them that information. All right, required to do that. And this one on the bottom here, all existing liens to be paid off before the title officially transfers. All right, we got to pay them off. If the liens don't get paid off, who bought the liens at the closing? The buyer. They own the liens. Buyer owns the liens. We don't want that, right? We don't want that. All right, so after the settlement, we're going to update the title and record everything. Disbursement of the funds, cancellation of the seller's liens. This is all done by the attorney. Any income tax reporting requirements, again, all done by the attorney. Don't worry about too much of that. So RESPA, remember we said we were going to come back, circle around to RESPA. And really what RESPA does, they're protecting consumers against abusive lending practices. We don't want, what they're trying to do is to keep the costs as low as possible. And they think that kickbacks and fees to agents for doing their job is an expense that shouldn't be incurred, okay? So the RESPA, Real Estate Settlements Procedure Act, applies to all first lien federally related residential loans. So if you're getting a federal loan and it's your first lien, you're going to have to abide by RESPA rules. Accounting gives you the requires the accurate accounting of the funds. Remember, I showed you the sheets, right? The breakout applies to all first lien loans. Requires accurate accounting of the funds, right? That's that settlement sheet. What are they paying? How much they paying? What's their true cost of lending, right? Down to the penny. And it eliminates kickbacks and unearned fees to the agents. Also limits that escrow reserve to 2 months. Remember, we saw that. So that was RESPA. That's RESPA. All right. RESPA covers the itemization of the settlement costs, right? We had that list. These are all the costs, title charges, escrows, everything else that was in the closing. The lenders are only required to retain settlement statements for 2 years from the closing date. We as brokers are required to hold them for 3. It does not change because they only have to keep them for 2. As brokers, we have to keep these records for 3 years from the last transaction. Okay, so please don't lose that. Don't lose sight of that. Don't get confused. So we already talked about your shopping for your home loan booklet. I showed it to you. Your loan estimate we've talked about, right? 3 days after the loan application. Costs that are controlled by the lenders can't increase. We showed you that, showed you where that is in the last chapter. We talked about some of these disclosures. We talked about the CD. We have to get that 3 days before the closing. Can't close unless we have it. If the buyer changes anything by more than 1/8 of a point on the APR, maybe they pay more money down, maybe they want to buy points or anything else like that. If that changes the APR by more than 1/8 of a point, we need to get a new closing disclosure. We need to start again. All right. And we still need that 3-day period. Okay. So just be heads up on with your buyer. If they just come into a windfall somewhere along the line, want to put a little more money down, it may change the closing date by a couple of days because we've still got to need to get a new disclosure. All right. Another time that we'll need a new CD if they add a prepayment penalty. All right. If they change the loan product, if they go from a conventional to an FHA, or they go from an FHA to a VA, if they change that, we need a new closing disclosure. And this is important for you. Per the Real Estate Commission, licensees are held responsible for the accuracy of information they should reasonably have access to on the settlement statement, which is either the HUD-1 form or the closing disclosure, which is the one we're going to be dealing with most, is the closing disclosure. HUD-1 doesn't look much different, but that's what they use if they're settling with cash. The closing disclosure statement is that is the one we're going to be using to work off of. So you're going to be responsible for taking a look at that. So all these numbers matter, right? All these things we've been talking about. So for example, the seller's broker responsible for the excise tax, ad valorem tax calculations, but they're not responsible for the title charges. Those are for the buyer. That's the buyer's responsibility and the buyer's agent's responsibility. So the seller will be responsible for the seller's charge, seller's agent, and the buyer's agent will be responsible for the buyer's charges. Okay. More about broker responsibility here. Not reporting a mistake may constitute willful misrepresentation under the license law. Now, they're not talking about overcharging your client. They're talking about undercharging your client. They're talking about both. But if you see something that should be charged to your client and it wasn't, you need to speak up. You need to let people know that there should have been a charge for this, right? Honesty is the best policy. Willful misrepresentation is not a fun thing, right? Not a fun thing. And the broker needs to ensure their clients receive a detailed and accurate closing statement from the attorney, right? That seems reasonable. That seems fair. All right, let's freshen our heads here. Debit is the amount that's going to be paid, right? Debit is debt. Credit is what we're collecting. All right, credit is what we're collecting. Debit is debt. So if we are paying for something, we get a debit. If we are receiving something, we get a credit. Okay, everybody hopefully got that clear by now. Broker's compensation is usually going to be paid from the seller's proceeds. That's going to be a debit to the seller. Attorney's fees, going to be a debit to the buyer. All right? Usually. Recording expenses, the buyer's going to pay for the transfer of title, but the seller's going to pay for the recording fees necessary to clear his title defects. So deed preparation on the seller side and title defects on the seller side, the buyer's obviously not going to pay for those. Those are going to get paid by the seller. Okay, those are going to get paid by the seller. Excise taxes paid by the seller, right? Don't forget to round up. Title expenses paid by the buyer. Loan fees, loan origination fees, discount points, everything else paid by the buyer at closing. Those are all debits to the buyer. Taxes and reserves paid by the buyer, debits. Appraisal fees, most often paid by the borrower. Due diligence fees debited from the seller, because what's got to happen here? If I go to closing, doesn't the seller have to give me my money back? Seller got to give me my due diligence money back, right? I get my earnest money back. I get my due diligence back if I buy it. So I'm going to get debited from the seller and credited to the buyer. Debited from the seller, credited to the buyer. All right. And any other fees we agreed to as we go forward. Earnest money deposit is going to be a buyer credit, seller debit. Due diligence fee, buyer credit, seller debit. Got to get that money back, right? We're going to do prorations on everything. Prorations on everything. When we talked about prorations, I'd rather do this on the sheets rather than just talk about it. Don't forget, we're going to use 30-day months, 360-day years for everything, unless you see a problem that says calendar year, but there may be one question I've seen in all of it that asks for a calendar year. But 30-day months, 360-day years. Now, don't forget that the buyer owes for closing on the for closing day on the interim interest, but the seller owns the closing day for taxes and rents and everything else. So that's important. Let's see what else we got. Let's go to the math packet. I'm going to bring up the math packet here. I want you to take out a piece of paper. I'm on page 16 in your math packet. And we're going to do this together, but I want you to use your calculator. And we're going to go through this closing problem. We're going to start it and then we'll finish it after the break, and then we're going to do a couple of them. On the left-hand side, I want credits. On the right-hand side, I want debits, okay? It's going to look like this, and we're going to do each one of these, okay? But before I do that, this is what the problem is. The seller listed his home for sale with a real estate company. An agent with a different real estate firm obtained an offer from the buyer that was accepted by the seller. The standard offer to purchase a contract form approved by the North Carolina Association of Realtors and the Bar Association was used. Standard contract. What is the total cash to close due from the buyer at closing? So these are all the facts that we have. So we're going to have to take a look at this. All right. Take a little bit of a look at this. Let's see if we can't get this just a little smaller so we can see it. What I'm going to do is we're going to work together, and I'm going to put my credits on this side, and then I'm going to come over here, and I'm going to put my debits on this side. All right. So the first thing is, all right, we're closing on June 12th, all right, for a property located in the city. Okay, that'll come into play later, right? Okay, the sales price is $87,500. Is that a debit or a credit to the buyer? A debit or a credit to the buyer? Does the buyer have to pay it, or is the buyer collecting it? There you go. It is a debit, all right? So over here on the debit side, we're going to put $87,500. Okay? All right, very good. The next one here says due diligence. The parties agreed to a 30-day due diligence period with a fee of $150. Well, we're closing, so what happens to that $150? Get it back, right? We get a credit for the $150. All right, so we got a credit. Now we also have earnest money for $1,500. What's that? Is that a debit or a credit? That's a credit. We're getting it back, right? The lawyer's holding it, so we get a credit for that. We get our money back. $1,500. This next one has three parts to it. The first one is we're going to get a 90% conventional 30-year loan. How much is 90% loan? And is it a debit or a credit? Remember our purchase price. Loan to value says it's 90%. It's going to give us a number. And is it a debit or a credit? So it is $78,750. And it's a credit because the bank is giving us the money, right? We agree? Bank's giving us the money. Okay. Now, the lender is charging a 1% origination fee. So what's 1% of the loan value? 1% of the loan value is what? Is it a debit or a credit? $787.50. All right, it is a debit because we have to pay it, right? We have to pay it. So $787.50. Now, the next part of this is 2 discount points. So how much is 2 discount points, and is it a debit or a credit? So we're going to take our loan amount and multiply by 2%, right? That makes sense. So it's going to be $15.75, and it is a what? Debit. We got to pay it, right? We got to pay it. So in this particular case, it's going to be $15.75. All right, we all happy with that? Excellent. This next line says, the lender will also collect interim interest at closing. So we have a loan for $78,750, and it is an 8% loan. We close on June 12th. How much is our interim interest? How much is our interim interest? We have borrowed $78,750. We have an 8% loan. All right. We have to divide it by what? We have to get a daily number and then figure out from June 12th to the end of the month, 30-day month, how much that is. So go ahead and take a minute and do that. Okay, for those of you who didn't figure it out, I'm helping you with this one. It'll take a little longer for the next one. 78 on the bottom here, 78,750 times 8% for the year is going to be $6,300 in interest. I need to find out one day. So we divide that by 360. So it's going to be $17.50 per day for interest. From June 12th, counting June 12th to June 30th is 19 days. So I'm going to multiply that by 19 days, and the price is going to be $332.50. Is it a debit or a credit? We got to pay for it. It's going to be a debit, right? It's going to be a debit. So we're going to add that over to our debit line. $332.50. Okay. Our next line is homeowners insurance. The first year's premium is going to be $350. Debit or credit? Debit, right? We got to pay that. Real property taxes. The assessed valuation for the real property is $76,450. The city rate is 58 cents per hundred, and the county rate is 65 cents per hundred of valuation. Taxes are unpaid and will be paid later in the year from the borrower's escrow account. How do we do that? Let's do some taxes. Okay, let's do some taxes. You did your prorations, do your tax problem. All right, so down here on the bottom, we have the assessed value at $76,450. Now remember, this is a property in the city, so we have to add the city and the county rates together. So that's going to be 1.23 per hundred, or 0.0123. So we're going to multiply that. So that means our taxes for the year are going to be $940.335. We're going to divide that by 360, which means $2.612 a day. Now, June 12th is the 162nd day. January, February, March, April, May. May, which is 5 times 30 is 150, and 12 days in June, 162. So the seller's got to pay $423.15. Does the buyer get a credit for that? Yes, buyer gets credit for that. So that buyer credit up here is going to be $423.15. Okay? Does everybody see how we did that? We've done tax problems before. This is just all of the math that we've done before. All right, we'll practice it up. We're almost there. All right, next one. The loan escrow account deposits required by the lender. 5 months of real property taxes and 3 months of homeowners insurance premium. So let's go back to the property assessment, right? What was our taxes for the property? Our taxes for the year was going to be $940,335. That was going to be our annual. Well, if we need to figure out what 5 months are, what do we have to do? Divide that number by 12 and then multiply it by 5. So take 940, 335, which is our tax rate, divide it by 12, and then multiply it by 5. The 12 is going to give you 1 month. Multiply that by 5. And how much is that? Okay, there you go. I'll take that. Now, that's $391.81. Now, the next part of it is 3 months of homeowners insurance. So we know what the homeowners insurance is going to be for the year, right? Divide that by 12, multiply it by 3 months, right? We're going to have to pay that, right? And that's going to be $87.50. Next line says items paid outside of closing. $20 credit report fee, $360 appraisal fee. If they're paid outside of closing, do we have to pay them again now? No, so we don't need to put them in here. We can just disregard them at this particular point. Okay, they're POC, paid outside of closing. All right, so now we have some miscellaneous expenses. Miscellaneous expenses, we have a closing attorney's fee. Is that a debit or a credit? That's a debit, right? We got to pay for that one? Yeah, we're going to have to pay for that one. So we have $400 for that. Title insurance premium, we got to pay for that, right? $175. Survey, we got to pay for that? Yeah, we got to pay for that. $195. Termite inspection, $55. We have to pay for that? Yes. Recording fees, the deed is $28 and the deed of trust is $30. Deed of trust being your mortgage, all right? So your recording fees are going to be what? Added together, $58. Excise tax, do we have to figure out the excise tax on this? Who pays the excise tax? Seller pays the excise tax. We don't have to do it. We're looking for the buyer's information. All right, I want you to do me a favor. I want you to tell me what the credits add up to. And then I want to, first, what do the credits add up to? Add those up for me, will you? So the credits are going to add up to $88.23.15. Okay. What are my debits? How much am I paying? What are my debits? There you go, 91, 907 and 31 cents. Okay, so if I'm debited 91, 907, 31, right? I need to subtract my credits because I got to bring the rest of the money, right? So I'm going to subtract 80,823.15. So how much do I have to bring? I have to bring to closing 11,084 and 16 cents. I had to pay a total of 91,907.31, but I had credits for 80,823.15. So I got to bring the difference in cash to close. All right. So I got to either wire that money or get certified funds to bring it to the attorneys. And that's how it's done. Simplified version of it, but that's how it's done.
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.